Hello and welcome. You're watching Nothing But the Truth. On Tuesday, when the Supreme Court referred the curative petitions in the Section 377 matter to a constitution bench, there was widespread euphoria and many thought that the repeat or even the reading down of Section 377 was simply a matter of time. Today we ask, how credible was that euphoria? What are the sort of hurdles and obstacles that lie ahead, and what can we realistically expect? Those are the issues I shall put today to one of the lead counsel in the matter, former Law Minister Kapil Sibal, who's willing to speak in this matter for the first time against all previous tradition, because this is not a dispute between two parties where he is a counsel concerned. Kapil Sibal, as I said in that introduction, there was a lot of euphoria on Tuesday when the Supreme Court referred the curative petitions to a specially constituted constitution bench. And many thought that perhaps the repeal or at least the reading down of 377 was imminent. But the truth is that in fact this constitution bench will itself decide whether to admit the appeals or not. And if it rejects them, then there will be no discussion on the merits and the substance of the matter. Am I right?
Well, I think the euphoria on the one hand is fair, and on the other hand is misplaced. It's fair because the curative petition could have been dismissed by the three judges themselves. To that extent, people should be euphoric.
In other words, the curative lives to fight another day, but it can still be dismissed by the constitution bench.
That's what I said, that it's genuine to the extent that it's now referred to five judges, and the five judges have to take a position whether the curative petition should be heard or not. But the court, in referring it to five judges, has indicated that there are constitutional dimensions in the matter which require to be heard by five judges.
I'll come to that in a moment's time. But you're saying to me that there is a possibility that it may not be heard at all.
No, it's the possibility that the court is going to hear arguments to decide whether or not to hear it as a regular matter.
Absolutely.
And admit the curative petition.
And at the end of those arguments, there's a possibility that the constitution bench may decide not to admit the petitions.
It's possible. It's always possible.
Now, as you said, there are indications from what the Chief Justice said on Tuesday that suggest that, in fact, the constitution bench will go on to hear the petitions. A, it wouldn't have been referred to a five-judge bench if it was simply to be rejected. Absolutely. And secondly, the Chief Justice said that these petitions involve very large and significant constitutional issues. He added that they raise questions with constitutional dimensions of importance.
Absolutely.
So, if you were to be a betting man, would you say these will be admitted, they will be heard, substance will be discussed?
You can never bet on what happens in a court of law. We've learned this through experience. But my heart tells me that when we are dealing with the rights of about 25 million people, and we are trying to foist Victorian morality on 25 million people, the court would be sensitive enough to actually deal with it.
Your heart and your head tells you this?
My heart tells me that. My head tells me that we should be able to make logical arguments to convince the court to deal with it.
Now, the jurisdiction that comprises the curative petition was established by the Supreme Court in 2002 broadly on two counts. Firstly, if principles of natural justice had been violated because an aggrieved or a vitally affected party had not been heard. And secondly, if it could be shown that the judges were biased. I take it the first doesn't apply in this instance. So will you then in court argue that Justices Singhvi and Mukhopadhyay, when they rejected and overturned the Delhi High Court decriminalization of homosexuality, did so with bias?
No. See, there are two issues here. All the previous curative petitions relate to disputes involving two parties, where there has been a violation of natural justice. This is perhaps the only curative petition where there is really no dispute between two parties. There is an interpretation of the Constitution in the context of 377 that is required, interpretation of Article 19, Article 21, Article 14. To that extent, this is a very, very unique curative petition. And the general principle will be that if there is a gross miscarriage of justice, curative lies.
This then brings to mind another issue. Many people have reported that in the exchanges that took place on Tuesday in court between judges and lawyers, the Chief Justice nodded in agreement to the suggestion that the Constitution bench should be asked to widen the otherwise restrictive scope of curative petitions. Does that suggest that could happen here?
I don't think we should comment on what what was informally reflected by gestures by any of the judges.
It was, however, officially reported by the Hindu.
Maybe so, maybe so. But as lawyers, we should not comment on it.
But I take it you're hoping, even if you can't bet on it, that in this instance, the Constitution bench will widen the otherwise narrow scope of a curative jurisdiction.
I would imagine so.
You would imagine so?
I would imagine.
The problem you face is this, that historically, only less than 1% of curative petitions have actually succeeded, which means the chances of this set of curative petitions leading either to the repeal of 377 or at least its reading down is statistically 0.23%. That's minuscule.
Maybe so, but I think this is a historic opportunity to undo a historic wrong. I think that comes very seldom. Comes very seldom before the court.
Will judges be aware that this is a historic opportunity to undo a historic wrong?
I think judges are also, human beings who know where the world is going and where India is going.
I'll come to that in a moment's time, because that, in a sense, is the core of how they'll respond. But the first problem is that a lot depends upon the character and personality of the judges who sit on this Constitution bench. Many people say that is always an element of lottery in this. The point is, it could be virtually make or break for you.
No, I don't think there's an element of lottery. I think that judges are very sensitive to societal issues as of today. Take 66A. The judges struck it down. You could have said the same thing about 66A.
Take the opposite. In 2013, 2 Supreme Court judges struck down Justice Shah's decriminalization of homosexuality.
Yeah. And that's why the judges have entertained a curative petition and now refer it to 5 judges.
Except if those 5 judges are like Singhvi and Mukhopadhyay, you'll get the wrong result.
I think that there was a problem there because the judgment was rendered after about 20 months. And many of the submissions that were made before the court were not reflected in the judgment. I really, there may be other reasons why that might have happened.
You're suggesting that in that case, the delay between the hearings and the judgment of 20 months meant that some of the arguments made weren't remembered by the judges.
It's possible. I mean, I cannot put my finger on it.
Again, something similar could happen, a long delay between the hearings and the judgment.
I doubt it. I doubt it very much.
So this time around, you're confident that if I can so call it, circumstances of last time won't be repeated?
I doubt if they'll be repeated for the simple reason there's an urgency, and the present Chief Justice has recognized that urgency, and in fact put the curative petition for hearing and has quickly referred it to 5 judges. So I think there is.
You don't think a lot depends upon the character and quality of the judges the Chief Justice chooses to sit on that bench, because that's his choice?
Look, all judges are human beings, and ultimately judges, also make mistakes, and judges also correct mistakes. So it's not an issue. I'm not worried about it.
All right, let's come to the arguments that are likely to be heard, and I want to first put to you the adverse arguments and ask how you would respond to them. One argument is that India as a country, the people as a nation, are not ready for the decriminalization of homosexuality. The 2007 Pew Global Attitude Survey suggested that 81% of the Indian people wish to retain 377 as it is. The argument then follows that even if urban, middle-class, westernized India wants change, rural India, where 2/3 of the country lives, purportedly does not. How will you counter that argument?
You must understand that judges don't necessarily go by uninformed public opinion. I think there have been many path-breaking judgments by the Supreme Court, despite the fact that at that given point in time on that particular issue, the country thought otherwise. So I think that that's really not a worry for me.
Judges are prepared to be leaders of public opinion rather than followers.
Absolutely.
A second argument, and this time it was an argument made by Justices Singhvi and Mukhopadhyay in 2013 when they declared the change brought in by the Delhi High Court as unconstitutional. They said this court is not empowered to strike down a law because the perception of society has changed as regards the legitimacy of its purpose and its need. How will you counter that argument if it's made?
Well, you see, you must remember that the judgment says several things, which I think is not quite right. For example,
you're talking about the 2013 judgment.
Yeah. For example, it says that you must presume the constitutionality of 377. because all legislations are presumed to be constitutional till proved otherwise. Now, 377 was put in the penal code in 1898.
1861?
Where was the constitution at that point in time?
So the presumption is wrong.
It's clearly wrong, right? Number two, they said this is a minuscule minority, but the Constitutional Court has protected minorities always, even if they are minuscule. He says, well, this is a minuscule minority, so why should we deal with it? Number three, it says it is for Parliament to decide. But you know very well that constitutionality of a statute or of a provision in a statute is not to be decided by Parliament. Parliament only enacts law.
It's to be decided by courts.
The fourth error, he says that so-called rights. No, I think that's a clear error when you talk about so-called rights. These are rights which are personal and precious to individuals. Sexuality is perhaps the most precious of personal rights.
All of that I understand, and what you're doing is going step by step to demolish the arguments presented in 2013 and to say that in fact these were wrong arguments, they don't stand up. But there is one other argument made in 2013 by Justices Singhvi and Mukhopadhyay when they struck down Justice Shah's decriminalization of homosexuality. They said Section 377 does not criminalize a particular people or identity or orientation. It merely identifies certain acts which, if committed, would constitute an offense. And therefore, those two judges concluded 377 is not discriminatory. If that comes up again as an argument, how will you refute it?
It's a clearly flawed logic, because an act is by an individual. So how do you sort of segregate the act from the individual?
In other words, what you're saying is that the act of what is deemed to be sex against the order of nature is intrinsic to homosexuals.
That's
you
right.
can't separate the two.
How can you possibly separate, and how can you make that a logical argument to reject the challenge?
And therefore the criminalization of the act is in fact the criminalization of people, an identity and an orientation.
Absolutely. Well, let's not talk of identities. People who indulge in that act are to be prosecuted or can be prosecuted and sentenced for life. Not just prosecuted, sentenced for life.
And all of this will be part of the arguments you present.
Of course.
So you will do two things, if I understand you correctly. First, you will demolish the grounds on which Justices Singhvi and Mukhopadhyay struck down Justice Shah's decriminalization.
Attempt to demolish.
Attempt to demolish. Attempt to demolish. I'm being generous in saying you will demolish, but you will attempt to demolish, and you'll hope you'll carry conviction with the Constitutional Bench.
I hope so.
But the second thing you'll do is to also point out that these are real people with real rights.
Absolutely.
And as long as this law continues, you are forcing them to be criminals for something that they can't escape from.
Right.
And secondly, you're denying them the liberty and the freedom and the dignity that as human beings they deserve.
Absolutely. Absolutely. Now, let me sort of give you a little perspective, if you don't mind. For example, if you look at the world and how the world has dealt with these issues, there are many, many countries in the world that actually recognize gay marriages as a matter of law, right? Then there's the second layer where they recognize not necessarily the gay marriages, but the fact that people are in this relationship and protected by law.
Those are called legally recognized partnerships. Britain was at that position before Cameron took it further.
That is the registered marriages. Yep. First is gay rights as a matter of law, then registered marriages, then registered rights, that is civil unions, may not be registered, and then unregistered partnerships are also recognized as matters of common law. So we are in none of the four categories. We're in a category where we criminalize this, where the rest of the world is even recognizing unregistered partnerships as matter of common law.
And so we come now, this is a very good point to come, to the arguments that you'll be presenting, not any longer demolishing the arguments of others, but the arguments you'll be presenting yourself. And the first one you're going to present is to say that this is a situation which ensures that India is the only liberal democracy in the world where what adults in consent with each other do privately is deemed to be criminal. And this is therefore an indictment of our democracy. In our democracy's interest, we need to rectify the situation.
I think the fundamental principle underlying Article 21, right to life and liberty, and Article 14 and 19 is that the state should neither enter your kitchen nor should it enter your bedroom.
And if it attempts to do so, or if it actually does,
it's per se unconstitutional.
Beyond being unconstitutional, it's also an indictment of our democracy.
Absolutely.
And therefore, those are grounds to rectify the situation.
Absolutely, without any doubt.
Will you go one step further and say that laws all over the world are not immutable? They change with time, they change with morals, they change with morality.
Absolutely.
If Parliament won't rise to the responsibility of ensuring that laws reflect the reality of the day, then that onus falls on judges to do so. Judges can't duck that.
We've seen Parliament do what it did the other day. Shashi Tharoor moved a private member's bill, and in Lok Sabha 24 people supported it and the rest opposed it. So he couldn't take it forward. So this confidence in Parliament making a law is entirely misplaced.
And does this then place the onus and responsibility on judges to rectify the situation?
But why should judges wait for Parliament to make laws when we're challenging the constitutionality of
Although that's exactly what Singhvi and Mukhopadhyay said.
Completely wrong.
Now you've got the proof of what happened to Shashi Tharoor when he tried to change it in Parliament, and you now say, look, Shashi tried to do it, he failed, the Parliament refused to accept. The onus is now on judges.
I don't think judges should wait for Parliament to make laws if the challenge is to constitutionality. That's the wrong way of dealing with the law and dealing with the challenge.
In fact, if the law that exists is unconstitutional, it's not for Parliament to change it, it's for judges to step in and say to Parliament, this is wrong.
Let me tell you why it's unconstitutional per se. Because if you look at 377, it deals with two issues together which shouldn't be dealt with together. For example, it deals with consensual sex in the privacy of your home and non-consensual sex anywhere. And he puts and equates both together. No, you can't do that.
You need to separate them.
You need to separate. And to the extent 377 does not separate them, it's unconstitutional. Unless you read it down.
There is another argument, I wonder, which you might seek to make when you are in court. And that is this, that all the scientific research suggests, in fact proves, I'll use the word proves in particular, that homosexuality is a God-given condition, not a man-made one.
Any number of studies.
If it is God-given, it cannot ipso facto be against the order of nature. If it's not against the order of nature, the very premise on which 377 stands collapses.
Absolutely.
Will you make that argument?
Absolutely. That's part of the petition.
Except
it's part of the data before the court.
Except that what you're doing there is assuming the court will be willing to accept scientific data, scientific research as convincing proof.
Well, the rest of the world are not fools that they're moved in that direction without scientific data.
But
I mean, that's the wisdom of members of Parliament all around the world, based on scientific data. Why would we not accept it?
So you're reasonably confident that when this scientific data is presented in an easy-to-understand form to judges, they will accept it, they will take it as proof, and therefore they will conclude that it's not against the order of nature, ipso facto, 377
hopefully, but
collapses.
the argument is at various levels. This is one of the arguments, certainly.
There is another argument you could make, that this is, and you hinted at it a moment ago.
I think, Karan, you better come to court and start arguing for us.
Thank you for that compliment. There is another argument you can make, and you hinted at it a moment ago in one of your answers, that this is a law that dates back to the British Raj.
Right.
It was imposed upon the Indian people in 1861. Till then, Indian society, Indian mores, Indian attitudes had not criminalized homosexuality.
Absolutely.
The British in 1861 bringing their morality of the day to play.
Victorian morality foisted on 1.2 billion people.
And criminalized it for us.
Yes.
The question is, since then, Britain has itself revoked and repealed the law.
Absolutely.
For India not to do so would be both illogical and anachronistic.
Oh, absolutely, without any doubt, without any doubt. Apart from the fact that it's per se unconstitutional.
So all of these arguments, you believe, will work with the judges?
I hope so.
When do you believe the Constitution bench will be constituted?
Well, that's not for me to decide, it's for the Chief Justice to decide.
But explain this to laymen. Does it have to happen in the tenure of the present Chief Justice, or could it be left for a later Chief Justice to take up?
I hope it happens now, because you must understand that criminalizing this activity in the consensual activity within the four walls of your house exposes and continues to expose on a daily basis these people to the fear. See, one, they are rejected within the house, within their family, and then they are rejected outside, and many of them are actually exploited by enforcement agencies, by the police, by other people who don't have the same wavelength in terms of their understanding. And therefore, no court should allow this criminalization to continue, and therefore there is an element of urgency to have it heard as quickly as possible.
I accept that there's an element of urgency But the question is this, will the judges accept? And I'll tell you why there could be area of doubt. In 2013, when Singhvi and Mukhopadhyay struck down the decriminalization, they argued, A, this only affected a minuscule fraction. If there's only a small number that's affected, that could raise questions of urgency or not. And secondly, they argued that in 150 years, less than 200 people had been prosecuted. And once again, they'd say, if it's so small and the number affected is so minimal, where's the urgency?
It's not a question of prosecution at all. It's a question of exploitation, stigma, indignity. It's nothing to do with prosecution. You must understand the fear. That's why we have closet.
The fear you're talking about, the indignity you're talking about, the exploitation you're talking about, I fully accept.
Nothing to do with
what
prosecution.
What I'm questioning is, will judges sense and feel the same urgency you do and constitute the bench immediately, or might prevarication and delay happen?
Why would the court have referred the matter to 5 judges if they didn't understand or appreciate the problem and the issues involved?
No doubt. The judges that referred the matter to a constitutional bench appreciated the problem, appreciated the issues, and realized that there are constitutional implications. It's another thing to say that they also accept that these have to be handled expeditiously and immediately. They may believe 2-3 years can lapse before they're done.
I doubt it very much. I think, in fact, one of the very positive things that have happened since Justice Thakur has become the Chief Justice is that he has, in fact, listed all constitutional matters to be heard every Monday and Friday, right? So in fact, what was not done in the past many years, the Chief Justice has done. And so therefore constitutional issues of far-reaching importance.
That again I fully understand.
Right.
But this matter, these curated petitions haven't been referred to the benches you're talking about that regularly meet twice a week.
Well, it can't be done overnight.
But it's going to an altogether new bench.
No, it can't be done overnight. It can't be done overnight. He could send it to one of the constitutional benches that are already constituted, or he could constitute a new bench. It's not an issue. But certainly the fact that he has moved quickly, and the fact that it's referred to 5 judges, and the fact that it's not been dismissed, and the fact that he's hearing a lot of matters, all the previous matters referred to constitutional are being heard. Obviously, I do hope and believe that this will be heard as quickly as possible.
Can I ask you this? At what point of time, if the new bench, the new constitutional bench hasn't been announced, should advocates or people who are otherwise interested begin to worry?
Oh, don't worry about it. We'll take care of that. If necessary, we may just mention it again.
You can do that. You have the right and power to do that.
With the permission of the Chief Justice, of course.
In other words, that mention again will be a way of reminding them and jogging the system.
Reminding them that this is outstanding.
It's a polite way of saying, can you get on with it, Your Lordship?
No, it's not a polite. We do it all the time. It's just, see, courts also have problems because there are so many matters that are clogged and are matters of great urgency. And sometimes it's difficult to hear all the matters together. So we appreciate the problems of the judiciary, but certainly this is an issue that should be dealt with as quickly as possible.
My final question, and it's probably the trickiest of the lot, although it's the one on which I think everyone wants to hear your honest answer. How do you estimate your chances of success?
I think we should win.
You really do?
We think so.
Can I ask you why? Are you simply speaking from your heart because you hope you'll win? Or does your head also tell you there's a credible chance of winning?
No, I think we should win for the simple. Apart from the heart telling me that, I think the mind says there's no logical argument against it.
And you're reasonably hopeful that 5 judges sitting on that constitutional bench will agree?
Because all judges ultimately are reasonable.
But sometimes reasonable judges come up with foolish judgments.
No, don't say that.
Isn't that why the Supreme Court in this instance is willing to look again?
It may be erroneous judgments, never foolish.
All right.
Right.
From your point of view, foolish or erroneous will mean the same thing because it will be the wrong judgment.
No, that's all right. But judges make errors like human beings make errors, and they are corrected, and judges correct them all the time.
And this is a moment for judges to correct it and give the Supreme Court a legacy.
It is a moment of hope.
And do you think the 5 men sitting on that will be aware that if they give the judgment, society hopes they'll have given themselves a legacy as well?
Absolutely.
So they will decide, within a sense, their own legacy in mind.
Absolutely, without any doubt about it, because there is a legacy that needs to be It would be a judgment that will open the doors for many other issues as well.
And a judgment, if it opens the right door, that will bring great credit and plaudits to the judges who open the door.
To the judges who open the door.
And they are aware of that.
That's right.
And that's another reason why they may go in that direction.
I hope so. I hope so. I really do hope so.
Kapil Sibal, a pleasure talking to you.
Thank you very much.